The question.
What's the tax effect, sir?
More than 2 crores. 2 crores 24 lakhs.
It's not open.
Question number 2, page 10. ATP 2AA1. In respect to the income from investment surplus fund with other banks, financial institution, NBFC, state government, central government, even when it is not denied by the SSC, the same investment are out of surplus funds. There is only one question. That man.
Let's read the impugned order of the IT-80.
Yeah. Page 52, Miller.
Page 52.
52. The point number 2, the London CIT fails to examine the clear-cut distinction between the implication of term business of banking specified in 80.
No, this is your issue, sir. What is the finding?
Finding appeal is allowed and revenue is dismissed.
Correct. So we look at the reasoning and tell us why it is wrong. This is your appeal.
Yes,
It's not
madam.
appeal is not allowed, sir.
Revenue,
Your appeal, revenue's appeal is dismissed.
revenue department appeal is dismissed.
Huh.
That's why I came before your lordship.
Huh. So just come to para 5.
On careful analysis of the impugned order of the authorities, page 54, Miller.
Correct.
Below, it is found that originally the SSC filed return for the period under consideration showing income of 252,493, where the assessment under section 143 was made on total income of 5 crore 48 lakhs 51,478. On appeal, holding the fixed deposit with various banks does not form part of the equity of any of these banks. Thus, this amount is not covered as per the annexure 2, as there is no mention of fixed deposit with any bank. Therefore, all the fixed deposits of the bank are included in annexure 2. Thus, all the securities are unapproved securities, and the interest on the same is taxable, and no deduction under section 80P is inadmissible. Thus, holding the computed the business income of the SSC of rupees 12 crore 46 lakhs, out of which deductions under section 80 fee admissible would be 767,94,210, and income from other sources was determined 8 lakhs 53,629. Thus, the total income was assessed at 4 crore 87,12,140. Agreed by the SSC, appeal before the London First Appeal Authority by this order. The SSC went in appeal before the tribunal, and the tribunal has disposed the issue number 4 by the order dated 29/2008, holding that on ground number 4, the learned AR of the SSC mainly ground on ground number 4.3, and submitted that the issue is covered by many decisions of the ITT Cuttack bench, which have been decided in favor of the SSC. According the issue was decided by the tribunal in favor of the SSC. However, with regard to ground number 4.1 and 4.3, the tribunal was not convinced with the argument of the learned AR of the SSC, and the issue was decided against the SSC. Following this, the order, the assessing officer has passed the assessment order dated 31/12/2009, determined the total income 2 crore 64 lakhs 87,84. Again, the SSC went to an appeal. CIT appeal and learned CIT appeal filed order dated so and so, held that the order of the CIT appeal dated 15/1/2008 has been merged with the order of the ITT 29/00/2008. Therefore, no further amendment to the order is possible at this stage. Thus, observing, he dismissed the appeal of the SSC. Against the order, the case came in appeal before the tribunal. The SSC filed a statement of computation income along with the copy of the assessment order and the appellant orders, and all these documents were sent to the assessing officer for verification, and he was asked to send report on the net income. Thereafter, the assessing officer, after the verification of the assessment record, arrived at the income of 2 crore 32 lakhs 27,215. This remand report was put to the SSC, who is submitted before the CIT, and the net income of 2 crore 32,27 computed by the assessing officer is not disputed. But however, it was submitted before the London CIT that after having the appeal affect the income of the SSC could be rupees 8,53,631. Then he come to the conclusion on careful consideration of all these things. The learned CIT appeal has directed the assessing officer to give appeal effect by the following para 4 of the ITAT order the 29.
So what is wrong with this order, sir? Nothing at all. Nothing is wrong with this order. The department is in appeal against an order dated 28 September 2012, passed by the Income Tax Appellate Tribunal, Cuttack Bench, bracket ITAT, dismissing the department's appeal ITA number 332/CTK/2012 for the assessment year bracket AY 2004-05. Paragraph. The questions ought to be urged by the department for consideration is regarding the ITAT allowing the claim of deduction under section 80 capital P bracket 2 bracket small a bracket small I of the Act of the Income Tax Act 1961 bracket IT Act on interest income on investments made in the unapproved securities given in Annexure 3 under section 24 of the Banking Regulation Act 1949, made out of the surplus fund, which according to the department is not approved by the Reserve Bank of India. Paragraph. It appears that this was virtually the second round of litigation before the ITAT. In the earlier round, after the assessing officer bracket AO passed an order dated 31st December 2009 determining the total income of the SSE at rupees 264,87,843. The SSE went in appeal before the Commissioner of Income Tax bracket appeals bracket CIT bracket A bracket. The appeal was heard in part by the CIT bracket A by the order dated 29th February 2012, asking the appeal assessing officer to give appeal effect by following an earlier order dated 2/9/2008 of the ITAT and para 5 of an order dated 25/2/2011. So thus it is seen that there were earlier rounds of litigation arising from and the orders therein were actually being given appeal effect to in the present round. Paragraph. After discussing the earlier orders, the ITAT has found that the CITA committed no error in giving such appeal effect to the earlier orders and determining the taxable income of the SSC. Paragraph. Having gone through the impugned order of the ITAT and having heard Mr. Chimanka, the court is unable to find any error committed by the learned ITAT. No substantial question of law arises. The appeal is dismissed.
Item number 2.
Substantial question is page number 10.
Yes.
Question number 2 is important.
Yes.
Whether on the facts and circumstances of the case, the finding of the learned ITAT is justified to state that as per provision of section 194C6 with effect on 1/10/2009 assessment SSC,
Yes,
there was
sir,
not
it's
to
only
deduct.
prospective. It is obviously only prospective. You see, the present appeal is directed by the department is directed against an order dated 30th November 2012 passed by the ITAT in ITA number 512/CTK/2012. By the impugned order, the ITAT allowed the SEC's appeal against the order of the CITA which had affirmed the order of the assessing officer bracket AO on the question of deduction of tax at source in terms of section 194 capital C bracket 5 of the Income Tax Act 1961. Paragraph. The SSC was carrying on the business of transport contractor by transporting materials for principals by hiring trucks whenever required, from truck owners. Stop. The truck owners are then asked to provide trucks on payment basis to transport the material. Stop. The truck owners furnished declarations in Form 15-I. In turn, the SSC filed Form 15J along with Form 15I. However, this was ignored by the AO, and he made an addition of rupees 392,32,730 for the assessment year bracket AY 2009-10. Under section 40 bracket A bracket small IA of the Income Tax Act 1961 bracket IT Act.
Truck on 194C2.
The case of the SSC was that once Form 15I was collected, the truck owner had discharged his responsibility and there could be no deduction from tax at source. However, the CITA dismissed the SSC's appeal and disallowed the sum of the aforementioned sum paragraph. Importantly, the ITAT noticed that the SSC's intention from the very beginning was that having taken subcontract for transportation material of rupees 10 crores, it was his endeavor to engage trucks and obtain a permanent account number as required under section 194 capital C bracket 6 of the Act, which was clarified with effect from 1st of October 2009. It was found that the SSC had engaged trucks for transporting material by way of a subcontract. Whereas the provisions of section 194 capital C bracket 5 is clarified, required a formal contract to be entered into. Having heard learned counsel for the department and having perused the impugned order of the ITAT, the court is not able to find any legal or factual error having been committed, which calls for interference. There is no substantial question of law that arises. The appeal is dismissed.
Item number 3.
No, question number 4. Circular number 487 dated 18/6/97 has clarified the TDS provision of section 194C apply. Page number 11 just.
No, you're arguing the same matter or the next one?
Next. Yeah.
Item 3.
You're now on item 3, sir.
Achha, okay.
Ah,
3 and 7 are the same.
all right.
The issue is here. The issue has already been answered in against the revenue
Ah,
in ITA number 2 of 2016,
all right.
and relying the judgment of the Mewa Sugar Mill Limited versus Commission Income Tax Rajasthan.
What's the date of the order?
Date of the order is 18/12/2019. Order is not available in the site.
All right. You see,
And here
the
I
order
will-
dated 18/12/2019 passed by this court in ITA number,
ITA number 2 of 2016,
2 of 2016.
dated 18/12/2019.
Yeah, these
But
appeals are-
only one I have to, there also I have stated that. Here the Honorable Supreme Court is dealing with the grant of monopoly. Here the only difference, the license fees, here the capital, you will also see the.
No, you just said it's covered against.
It is
you.
covered, but that observation I have, whatever I have stated in that is that I want to submit that you will also make, because that order was not available in the website, I mean, our High Court site. So therefore,
No, if you've got the order, then you show us the order.
I have sent it to the Revenue Office, but I don't have any copy of that order.
What is the observation you want?
Observation I want to here only the language is different. Here is a privilege fees paid to the assessor to secure the business from
It's
competition.
okay, sir. I think let's not get into all that. Yeah, all right.
Please.
No substantial question of law arises. The appeal is dismissed. All right.
Item number 4.
3 and 7 both are same.
No, 4 is also the same.
No, 4 is some. 4 is not. I don't think any. That is factually
3 and 7 is.
3 and 7 and 4. The question which are framed, I think it is factual in nature. I don't think any.
Yeah.
I don't want to.
Yeah, this appeal is directed against an order dated 14 February 2013, passed by the Income Tax Appellate Tribunal. Cuttack Bench, Cuttack bracket, IT80. In IT SS A number 76/CTK/2012 for the assessment year bracket AY 2009-10. In allowing the SSC's appeal, the IT80 held that the addition made by the assessing officer on account of unexplained loans and advances was unjustified, and loans as well as on account of capital reserve was unjustified. Paragraph, having heard learned counsel for the department and having produced the impugn order of the ITAT, the court finds that it turns purely on facts and there is no substantial question of law that arises for consideration. The appeal is accordingly dismissed.
Item number 5.
Permitted to withdraw.
Counsel's petitioner seeks leave to withdraw this petition. Dismiss this withdrawal.
I am filed in, I'm for the Union India.
Orders item number 6.
May I please, sir? Petitioner filed this interim application for recall of the order dated 7th of 2022. My lord, in the last occasion, when the CRLA 170 of 2001 was taken up for hearing, my lord, that time, my lord, due to technical glitch, my lord, I was the conducting counsel, could not join the proceeding due to, my lord, technical problem of the internet, my lord. So my humble prayer, my lord, the last occasion, my lord, has directed to the personal appellant, appearance of the appellant along with the case has been maybe transferred to the legal aid, my lord. So my humble prayer, my lord, kindly recall the order of the last 7th to 2022 and
Let him remain present, sir. We'll also let
Yes, so what the personal appearance is
criminal
concerned,
appeal, no harm if he is present. No harm if the appellant is present. It's a criminal appeal after all.
Yes, please. He must have been intimated in the meantime.
We are ready for this with paper book, my lord, and we are.
It's okay. So remain present on the next day, no problem.
So
It's
appellant
only 14th March, which is not a far off date. Where is the appellant residing?
says Bhubaneswar, my lord.
Bhubaneswar. He can't come from Bhubaneswar here, please. Ask him to come.
So
He said no grounds made out for.
we may be permitted to argue that.
That we will permit you. If you're there, we will permit you. We don't know if you're going to be there. Today you're there, tomorrow you may not be there, we don't know. So we're not recalling, sir. No ground made out for recall. The application is right.
So has been transferred to legal aid, my lord. That aspect.
It's not transferred to legal aid, sir. You don't know, you're not reading the order correctly. How can we transfer an appeal to legal aid? We can't. We simply asked legal aid panel counsel to assist the court. That's it. Yes.
Orders item number 8.
Milord, 8, I need some time because I don't have file. I permitted to collect the file from the.
It's a 2013 appeal, sir.
Yes, Milord, one chance.
Just see what it is. Trade margin, Trades Commission. We just passed the order. No substantial question of law. The appeal is dismissed. Yes.
Item number 9.
Item number 9, Lordship, deficit court fee of rupees 24. I'll pay in the course of the day, Your Lordship. In this case, Your Lordship, my prayer is very simple, Your Lordship, for direction to carry out the order of eviction of OP number 4 to 23, Your Lordship, from the government land.
So there's no representation you made way back in 2015. You've not made any recent representation. Please make a recent, again, a refreshed representation. It will be open to the petitioners if the cause of action still survives to make a fresh representation to the authorities, and after following up on such representation to seek appropriate information.
Item number 10.
My lord, item 10, I'm appearing from virtual mode, my lord.
Yes.
My lord, this is a PIL file questioning the legality of the transfer of forest clearance from POSCO in 2011 to JSW in 2019 in violation of the Forest Conservation Act and the rules on the basis of an administrative guideline. Annexure 8, page 288 is the
This representation has been delivered.
My
There's
lord,
no proof of delivery of representation, sir. Come to
lord,
page 290.
my lord, I will submit. I will give me a week time. I will give the receipt. I forgot to file the receipt of the representation. I can find it.
Ms. Patnaik is there.
Ms. Patnaik, are you aware if this representation is available to the government?
For your lordship.
All right. Mr. Devdas needs time to produce proof of having made the representation to the government. That is request list on 8th March.
Hold it, my lord.
Item 11.
Please, your lordship. My lord, Mr. Devashish Tripathi, contending counsel, Mr. Devashish Tripathi is engaged as a central government counsel.
It's all right. What is the matter about? You're there. What is
My
the
lord,
matter about?
my power is not reflected, my lord. Today I am interested with the file and I will file fresh vakalatnama in this case. Matter is related to illegal mining query, my lord.
This is PIL.
My lord.
So have you made a representation?
Today I have been interested with the file, my lord.
No, have you made
I
a
have
representation?
not gone through the record.
No. There's an earlier order 28/1/21. Where is that? Where is that earlier order 28/1/21? Just say the file of Red Petition Civil 24703 of 2020 be requisition for the next date. List on 9th March.
Item number 12.
Counsel the petitioner seeks leave to withdraw this petition. Dismiss as withdrawn.
Item number 13.
My lord, item 13, I seek your lordship's permission, may kindly be granted to withdraw this petition and file a better petition, my lord.
All right. Memo is taken on record and it's disposed of as withdrawn in terms thereof. All right.
My lord may kindly grant me liberty to file a better
Yes, yes, with liberty to file a fresh petition. All right.
Grateful, your lordship.
For admission, item 14.
But this is a case, I have challenged the selection done by the Justice of Cuttack, my lord, for the post of Coffee Star Club, my lord. The only determination is the vertical and horizontal interpretation, my lord. My lord, what they have done, my lord, three special
1 minute, let
category-
us see what we should notice to 1 and 2 last time.
My lord, one
Well, we have filed the counter in this case.
When did you file it?
Not on
The
14th
joint
of
is also
12.
filed. All right. We'll
My lord,
list it for hearing on some
one
other day.
thing, my lord.
Ah.
My lord, Justice of Cuttack has filed the counter, but the state government has to file counter because the 17 resolution, I have
So why counter is filed only by the
request from
judgeship?
the state government.
Yes, by
Because
the
they have,
registered civil
State
court.
government is to also file an affidavit, sir.
my lord,
Lord, there is an
Counter affidavit
IA.
of the state government will file within 4 weeks, joined up for the next date. 11th April.
my lord, this will be a leading decision. All over the state, they are making mistake in horizontal and vertical.
All right, sir. All right.
So, let's fix a date, my lord.
11th April, sir. Item number 15.
My lord, 11th.
11th April.
My
Item
problem,
15.
my lord.
Item number 15.
It's just Mongol Jodi PIL matter.
Yes,
my lord.
What has happened, Mr.
Yes, Lord. Mr. Nanda is also there and the district fisheries officer as well as the DFO.
Yes, Mr. Nanda, tell us what happened.
Sir, good morning, sir. I had a consultative meeting with the Fisher Folk of Mangalajodi.
Yes.
And then also the bird protection group, those are protecting the migratory birds. There are 3 societies those are protecting. So it transpired that, sir, they are using the Fisher Folk are using the main channel while traversing to the Chilika water body. It's almost 8.4 kilometer, and they with repeated emphasis and my submission before them, they are not willing to stop using that motorboat through the main channel. But after a lot of deliberation, they have agreed that the IB area, which is crisscrossed by many sub-channels on which we have a lot of birds, they will not be using that.
So they will stop to, they are going to stop to using. They will not use it.
They will not use the motorized boats in the sub-channels, but the main channel, which is around 8.4 kilometers from Mangalajodi village to the Chilika water body, they will use that main channel with motorized boats.
Yes, Mr. Ashish Kumar Mishra.
May I please, my lord. My lord, I have received the counter, my lord. Kindly glance at para number 3 in the counter, my lord. In the last line, my lord, he has mentioned the area has no legal recognition and the area is also not protected by any statutory rules and regulations, my lord. Then in para number 6, my lord, he has clearly mentioned that furthermore during the consultation, the fishermen admitted to be using the main channel for assessing.
Yeah. So he's making a distinction between what he's calling main channel and sub channels.
Yes, my lord. And here he has also admitted, my lord, that on being repeatedly impressed upon.
So they don't want. They'll say they want to continue using motorboats in the main channel.
Yes, my lord.
So what is your stand?
My lord. Let's say
what is the stand of the Chilika Development Authority, sir? What is your stand, Chilika Development Authority?
Sir, my stand is since this IBA doesn't have any legal statute.
So it should have. We'll have free motorboats all over the place.
No, sir. Sir, only my submission and my what I have filed in my affidavit is that they should be allowed to only use the main channel. Since more than 200 motorboats have been not only used in Mangalajodi but also.
What does it do to the bird? Have you studied what does it do to the bird population?
Sir, if the main channel is used, the disturbance to the bird population is very minimal because they are all in the sub channels. They have adjusted to the sub channels and water bodies there.
Can you show us a map of main channel and sub channels?
Sir, yes, I have filed it in my affidavit. It's in
page 9.
A2.
is number 6. So there are 3 main channels. AB is from Mamlajodi village. Then there is CD, which is used by Bhusuldapur villagers, and then there is EF, which is used by Kalupada Ghat villagers. But then you can see that there are a lot of other sub-channels inside those IBS demarcated by blue. The IB is around 8.3 square kilometer, and the birds are congregating in these sub-channels mainly, sir.
Why can't you have only one main channel? Yeah, A to B. Why have so many sub-channels, so many main channels?
Lordship, may we be permitted to mention on behalf of the intervener applicant, Lordship?
Yes.
Lordship, from Mangalajodi point to Chilka, there are 5 channels, 1 main channel and 2 sub-channels on the 2 ways. So the fisher folk, they request to the Chilka Development Authority to dig that main channel and 2 sub-channels so that they can conveniently reach to the deep Chilka. That is the request on behalf of the fisher folk. And on the date when the learned CDA executive officer was present, the fisher folk also requested the Chilka Development Authority to dig this 1 main channel and 2 sub channels so they can use that sub channels, and on other parts the birds will not be disturbed.
No, but why don't you use only 1 main channel, sir? Why so many why sub channels?
Lordship, the problem is that to deep Chilka, it is so wide. Suppose they will only use the main channel. If they will reach to the 8 kilometers to the main Chilka, then they will take the left hand around 20-30 kilometers for deep Chilka fishing. So that is the problem, Lordship. So from main channel to entering into the deep Chilka, it is 8 kilometers, and 2 sub channels, it is hardly 4.5 to 5 kilometers, Lordship, 2 sub channels. So that is the request on behalf of the fisher folk of the Mangalajodi Chilka point, Lordship. And peculiar thing is that during 3-4 months, the people of Mangalajodi, they are quite cautious. Even they were earlier engaged in hunting to the birds. Nowadays, all these beginning from child to old age people, they are quite cautious to preserve the migratory birds. Those are flying from different parts of the Siberian and other parts of that northern part of Asian countries, Lordship. So,
do you have any, sir, the CDA, is it advised by any wildlife experts, bird or ornithologists?
Sir, we are repeatedly being advised by members of BNHS. We have their people at a subcenter at.
Can you get one of them to address us?
Okay, sir.
Because we are not satisfied with this explanation you are giving us,
sir.
May I please, my lord? It is creating a conflict between the statement what he is submitting before this honorable court and what he has narrated in page number 4, my lord. In page number 4, para 8, he has mentioned that Chilka Development Authority has requested Department of Fishery, Government of Orissa in the past to restrict the movement of motorized boat inside the sub-channel of the IBA. The Fishery Department may examine the issue, and a suitable order to ban the use of motor inside the sub-channel of the IBA may be possible.
Let us ask the Forest Division that.
Chilka Wildlife Division, sir.
Wildlife Division.
DFO is there, sir.
Mr. Mishra. Sir, namaskar, sir.
Namaskar.
Sir, we are protecting the birds. We have no right to seize the motor boats in the sub-channels or the mechanized boat which are licensed by the Fisheries Department.
Okay.
Livelihood.
What is your stand? Your stand is the same. You want to allow or you don't want to allow?
If the main channels are open, then we can protect the sub-channels with the help of the Fishery Department by regular patrolling. We are continuously patrolling duty we have done during from October to and March with the local persons engaging as squads. After that, our staffs are engaging to protect the residential birds.
All right, who's for the fisheries department now?
Sir,
Mr. Shashank Sahu.
Shashank Sahu is there, sir. Like.
Sir, namaskar, sir.
Namaskar.
Sir, actually, we are giving the license as per the UNFRA rule, sir. And the forest department may give the conservation of the bird protecting that area. So then we may pursue the matter to the gazette notification for under UNFRA implementation of UNFRA Act.
All right, you do whatever you have to do, sir. You have to make a stand clear and please do that.
Sir, can I come in here, sir?
Yes.
Sir, our stand is that they may only be allowed to use the main channel, and as requested by them, we are also digging the main channel and making it more navigation. But all the sub channels under UNFRA Act, as we have requested, we want a ban on that.
Yes.
That is also agreed upon by Fishery Department, my junior colleagues those who are present here, and by the DFO. The main congregations are in the sub channels, and we should avoid that, sir.
All right.
My lord, beside my lord, the Nalavarna has been declared as the sanctuary under Wildlife Protection Act, my lord. But this
So why not
Mangal
Mangal Jodi is the question? Yeah.
Yes.
You see, in an affidavit filed today by Shri Shrishanta Nanda, the Chief Executive, Chilika Development Authority, it is stated that a consultation was held with the fisher community on 14th February 2022 at the site, where the fisher folk expressed the view that they should be permitted to use the single quotes main channels, unquote, through which motorized boats will traverse. This has been indicated in a satellite imagery map, which is at Annexure C/2 to the affidavit, as
Lots
points A to B, C to D, and E to F. Full stop. In red color. Full stop. They've agreed that they may not use the motorboats in the sub-channels indicated in blue in the said map.
Lordship, the fisher folk, they have requested to use only 2 sub-channels. There are many sub-channels. Apart from the main channel, which is the distance around 8 kilometers, if they will not be allowed to use the 2 sub-channel, Lordship, it would be most inconvenient to the fisher folk.
No, what, Mr. Nanda, tell us, what did the fisher folk say about sub-channels?
2 sub-channels. That
No,
has
1
been-
minute, sir. You are not Mr. Nanda. We were asking a question to Mr. Nanda.
Sir, they were convinced that they will, if the main channel is dug up and if it is maintained by Chilika Development Authority,
Yeah,
which,
all right.
the work which
Subject to
was
the main
started-
channel, yeah, subject to the main channel being dredged and made more navigable. Paragraph. In the affidavit, the Mangal Jodi is characterized as an single quotes important bird area bracket IBA. Which has been identified as such using an internationally agreed set of criteria and as being single quotes globally important for the conservation of bird populations, unquote. Yet it is stated that the area is not protected by any statutory rules and regulations. Full stop. The IBA spans 88.3 square kilometers of marshy land with emergent vegetation and is a place for roosting and nesting of migratory birds. Full stop. The stand of the CDA is that the Department of Fisheries should examine the matter under the provisions of the, what's the expansion of this OMFRA?
Orissa Marine Fishing Regulation Act, sir, 1981.
Orissa Marine
Fishing
Regulation Act. Fishing Regulation Act 1981, bracket OMFRA Act, bracket. to restrict the use of fishing gear for which license is granted in specified area. Paragraph. This court has heard the submissions of the DFO Chilika Wildlife Division as well as the
Chief Executive of CDA,
no fisheries
District Fisheries Officer,
as well as the district fisheries officer.
Mr. Sasank Sahu.
Mr. Shasank Sahu, District Fisheries Officer. The Fisheries Department and the Wildlife Department will, in consultation with each other, come up with a concrete set of measures to put in place to regulate the activity in the area and restrict the use of motorboats only to the main channel stop. The two departments will also consult experts, including the Bombay Natural History Society.
Yes, sir. BNHS, Bombay Natural.
Bracket BNHS. A representative of the BNHS is requested to remain present on the next date to address the court on what should be the best course of action to be adopted in this regard. List on March 10th.
My lord, copy of the counter may be also directed to be given to us.
Yeah. They'll be given.
So much obliged.
Consul.
Luscious, may I take the liberty to actually mention an urgent matter? Actually, this matter was listed before the division bench headed by Justice Sarangi, but he refused to hear the matter. It's an urgent tender matter. If I don't mention it today, it can't even come up on Monday in any other bench. That's the reason I mentioned at the last hour. He refused to hear the matter.
All right, ask the DR to place it.
Luscious.
All right. Over. All right. Sorry.
Supplementary stress admission item number 1.
Praying for an urgent, your lordship. On behalf of Suryakanta Das Mahapatra, he is suffering from COVID.
All right, constantly petitioner is stated to be unwell. List on 8th April.
Item number 2.
Lordship, I'm for the petitioner. Lordship, at page 19 is the arbitration clause at clause 27. Page 19 of the brief, Lordship.
All right, notice returnable 25th March. All right.
Much obliged.
For orders, item number 3.
Well, item 3, in this case, I am appealing for the opposite party. On the last occasion, my lord directed me and Mr. Acharya to take instruction from my lord Justice D.P. Mahapatra whether he wants to continue with the arbitration or not. And we went to his residence, but he said that he come after 2-3 days. So I pray that the matter be taken up 1 week after, so that in the meantime we can take instruction.
All right, at the request of Mr. Sarangi, list on 11th. Sorry, 25th.
My lord.
25th, my lord, is there's some
All
person.
right. 4th March.
Please.
Yes, sir.
4th
Yes,
March.
sir. Obliged.
Item number 4.
My lord, I have filed this, my lord, interim application. The lordship kindly see on the day this review petition was listed, my name is not reflected on that. My lord, page 5, I have given that list. And my name, I have filed Oklatnama since August, and it was listed in November. So it is.
All right. So for the reason stated, the order dated 5th November 2021 is recalled, and review petition 337 of 2019 is restored to file. Now, come to the review petition. Come to the review petition, madam.
My lord, matter is all about, my lord. This is the review application. On the date it was listed, on that date the lawyers and that cessation of work, no word is coming to the court. Your lordship, kindly see the order, page 9.
16/10/2019.
My lord.
You are seeking review of 16/10/2019.
My lord, that order, my lord, I'm that is at page 16.
It should be a recall order then. If it's dismissed for non-prosecution.
That is a review to be restored. My lord, in the review petition itself, I am saying, my lord.
Oh, all
my
right.
lord.
But it's covered by.
That's the wrong order. In that order itself, that was mentioned, my lord, para 6, because it was no lawyer was there, and this is when.
No, but you're not covered by the Supreme Court order.
No, that is, my lord, it is an education case order number, my lord. Kindly see page 16. That is against the education case number 139 of 2013. Government moved this honorable court. And before that, government first appeal was already been dismissed, my lord. It is after dismissal of the first appeal of the government, we filed the implementation education before the education tribunal. Education tribunal, my lord, that is 139 of 2013. Against that order, government to kill some time, moved this honorable court. And that was been allowed by this honorable court under impression that it is a first appeal against the order of first instance court, but it is an education case, my lord. It is a implementation of the order of the education tribunal. That was already been dismissed,
Any
my lord.
notice
That
will now
order-
have to go in this review.
My lord.
In this review petition, notice has to go.
Review, my lord, that because this order says.
No,
my lord-
so in the review petition, notice has not yet been issued.
Yes, my lord, that's right.
So notice be served to the counsel appearing for the non-applicant. That Mrs. M. Sahu was responded in person.
So, my lord, that day, no lawyers were appearing, and there are 300
It's a
cases.
notice returnable 8th April. Your tracking report will test by registered speed post.
Item number 5.
I remove the defect, my lord.
All right. List after removal of defects. List on 25th March, defects were removed by them.
Item number 6.
Same.
6, my lords, I may be permitted to withdraw the petition with the liberty to refile the same. With the, if the cause of action.
Petition seeks leave to withdraw the present petition with liberty to refile it.
Item number 7.
And 7
This is
also
withdrawn
same, my
with
lord.
liberty to refile.
Remove the defect, my lord.
Same order as in 5.
Item number 8.
May I please? Page 47.
What is the defect number 9? What is defect 9? Provision of law and not litigating cost settle. All right. Say notice returnable 25th March.
Grateful marks.
Defect we removed in the meanwhile. Right.
For admission, item number 9.
Let's may it please, your lords.
Yes.
Last occasion, your lordships have directed fresh notice to be sent to the opposite part number 3. I order dated 17/12/21. The noting is that he has not claimed.
That's right.
And now coming to the merits of the matter, my lord, I have given a gist of short note. On 15th, I have filed. I believe it is there.
May I pray, my lord?
Yes.
This
earlier council has been changed. Now I entered appearance. I
Oh.
request my learned senior, they can give a copy of the same. Then for any date, maybe let's.
All right, Mr. P.K. Padi enters appearance today. A copy of the complete set of the papers be served on him by Mr. Rao within 3 days. This on 22nd April, sir.
Oblige, ma'am. Item number 10.
Mr. Sangare is not well, maybe taken up 1 week after.
Who's unwell?
Mr. Sangare.
He's unwell.
My lord.
No. What are you asking? I don't even know what you're asking. I'm just asking.
Not well.
You're not
Mr.
talking
Sangare is
clearly.
not well.
Sorry?
Adjournment for 1 week.
For what? What is the reason for adjournment?
Mr. Sangare is not well, my senior.
Counsel to petitioner state to be unwell. List on 29th April.
Item number 11. Item number 12.
My lord, item 12 permitted to withdraw, my lord. Not place, my lord.
Seeks leave to withdraw this petition.
So it is RBP 46.
This is arbitration petition, sir.
Yes, proceeding. South Indian.
Ours is item number 12, my lord.
You are appearing.
Yes.
All right.
I think he's mistaken with the
I know.
numbers, some
Some
other.
other list. Correct.
Item number 12.
Yes.
Yes.
12, my lord, permitted to withdraw, my lord.
Sir, that is a different list. Probably you're wrongly mentioning here.
I'm in item 13, I'm sorry.
Yes, carry on.
My lords.
Huh.
My lords, here, the sole dispute is, my lords, whether a particular clause of an agreement can be constituted to be an arbitration clause, my lords.
Who's for the other side? You're there.
Your Lordship, I'm
Lordship, my lords, we have removed the defect. Defect has been removed, my lords. We have uploaded the challan. I think the defect has been removed.
Yes, yes, it's all right.
And secondly, my lords, we have filed the rejoinder, my lords. It's filed online. If your lordships have got it, otherwise I'll give.
No, we've not yet got it.
My lords. Here the.
No, we don't have it.
Otherwise, we'll give a hard copy.
All right.
We have received a copy, Your Lordship.
We don't have it. I think we'll have to give a copy. Can we have this on some other day?
Yes, my lords.
All right.
Because this needs
The
to be
jointer
argued.
is been handed over and it's taken on record. List for final hearing. 22nd? 22nd April.
Item number 13.
My lords, here. Sorry, my lords, I'm appearing for the opposite party. I don't know. I think.
Mr. Ratha was there. I heard
Yes,
it.
Lord, I am here, Lord. So my video is not opening, taking little time to open my video. Yes, it is open.
All right, all right.
Lord, it's an arbitration application for appointment of arbitrator. Now, to my knowledge,
Must be the problem of venue.
yes,
When
Lord,
you,
venue
my lords,
and,
already they have withdrawn this application because we pointed out that Mahanadi Pellet's judgment, Ramani Pellet's judgment. They have withdrawn the application. Your lordships gave them leave to approach in accordance with law. Again, they have approached this honorable court now.
No, earlier withdrawal. Probably Mr. Kanungo is referring to earlier withdrawal here, in this case.
Yes.
In this case.
So, Lord, earlier withdrawal was not because of jurisdictional issue. Earlier withdrawal was because a notice of arbitration was not given. So
No,
that
no,
I found from the record. And that
No, but now the problem will be then venue.
venue, yes, my Lord, that Your Lordship will kindly turn to
So
page
the Brahmani
49.
Pellets is coming in your way then.
For the judgment.
Yeah, Brahmani Pellets judgment of the Supreme Court.
That will be there. That will be
Yes. So you can go to the appropriate court, sir. In view of the judgment in Brahmani Pellets, Mr. Ratha states that the petitioner may be permitted to withdraw the present application to approach the appropriate court. Disposed of is withdrawn.
My
Liberty is
name may be reflected.
Yes, absolutely.
Deeply.
All right.
But yes, my Lord, as Your Lordship rightly says that judgment of the Honorable Supreme Court.
Yes.
But here, arising out of the identical nature of agreements, my Lord, the Reliance has already conducted arbitration in the case of other retailers. In our
Probably Brahmani Pellets was not there then.
No, prior to that.
All right.
One password.
I'll check.
Password matter item 11.
Deeply.
My lord, item 11, my lord. I am on behalf of Mr. Janmejay Rai, my lord.
Yes.
We have not received the counter affidavit, my lord.
All right. The counter of the opposite party be served. Who's for the government? Oh, not government. Mr. Sailesh Narayan Biswal. Who's appearing for the opposite party? 11. All right. The counter be served on counsel to petitioner within 3 days. Rejoinder for the next day. This on 29th April, sir.
Oblige, my lord.
All right.